Hello, everyone. My name is Sasha, and I'm here to talk to you about employment discrimination, specifically relating to the American with Disabilities Act, which is commonly referred to as the ADA. The American with Disabilities Act was signed into law in 1990 by President George H.W. Bush. The ADA was modeled after the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, sex, or national origin, and Section 504 of the Rehabilitation Act of 1973. The ADA is an equal opportunity law for people with disabilities. To be protected by the ADA, one must have a disability, which is defined by the ADA as a physical or mental impairment that substantially limits one or more major life activities, a person who has a history or recorded of such an impairment, or a person who is perceived by others as having such an impairment. The ADA does not specifically name all of the impairments that are covered. This act is made up of 3 titles. Title I applies to all employers with 15 or more employees. The regulations for Title I define disability, establish guidelines for reasonable accommodation process, address medical examinations and inquiries, and define direct threat when there is a significant risk of substantial harm to the health or safety of the individual employee with a disability or others. Title II of the ADA prohibits discrimination against qualified individuals with disabilities in all programs, activities, and services of public entities. It applies to all state and local governments, their departments and agencies, and any other instrumentals or special purpose districts of state or local governments. Title III prohibits private places of public accommodation from discriminating against individuals with disabilities. Examples of public accommodations would be hotels or restaurants. In 2008, the American with Disabilities Act Amendments Act was signed into law and became effective on January 1st of 2009. The American with Disabilities Act Amendments Act made a number of significant changes to the definition of disability. The changes in the definition of the disability apply to all 3 titles. The change in definition was based on Supreme Court rulings that occurred during the late 1990s and the early 2000s. There were decisions made by the Supreme Court which should have protected the disabled employees. The following are a few examples of which they occurred. I will talk about a couple of these cases in depth. The Sutton et al. Versus United Airlines. In this case, the court's definition of disabled under the ADA led to instances where employees could terminate a person from a job because of a physical or mental condition and then argue the condition was not serious enough to constitute a disability. The U.S. Airways case versus Barnett, this case gave the court's characterization of a reasonable accommodations as special and preferential, which fueled misconceptions that the ADA gave people with disabilities some type of advantage over those without disabilities. These are just a couple of the examples. I know I've listed some additional cases referencing this, and you can look those up and see additional information in regards to those. So let's talk a little bit about the perceptions that the ADA has changed as far as things with this act and when they were passed. In a research study performed by Robert Gould et al., they looked at the impact of the ADA in regards to knowledge, attitudes, and perceptions of disabled employees from both an individual and employer level. So from an individual level, while the ADA provides a legal framework for individuals with disabilities to challenge discriminatory practices, they broke this down into several subcategories, but from a high level, the 4 categories are self-advocacy, disclosure decisions, impairment type, and complaint process, and knowledge barriers. So from a self-advocacy perspective, people with disabilities lacked some of the self-advocacy skills, And if they were developed in relation to knowledge about their rights under the ADA, there is evidence that the individual knowledge has grown in relation to increased choice and access. Disclosure decisions. Knowledge of the ADA facilitates the decision to disclose one's disability status. The evidence shows that a person is more willing to disclose when they are aware of their legal rights. Conversely, people who are less aware of their ADA rights are less likely to disclose. From an impairment type and complaint process, people with cognitive impairments experience barriers while filing formal ADA complaints to the EEOC due to the lack of knowledge about the complaint process. There is evidence that derive from the notion that people with cognitive impairments are most likely, compared to other types of disability, to have formal ADA complaints dismissed due to improper filing before they have a chance to be reviewed in full. Some of the knowledge barriers are people with stigmatized disabilities or and require more complex accommodations have increased knowledge barriers to applying their rights under the ADA during the job search process. This evidence comes from people with disabilities expressing difficulties or insufficient knowledge about how to apply the ADA to their individual job searches. From an employer perspective, they broke the study results down into 4 high-level categories with subcategories underneath them. The 4 categories being hiring and advancement, reasonable accommodations, knowledge about the ADA, employer concerns. So from a hiring and advancement perspective, advancement decisions are impacted by anticipated need for accommodations on the job supports. Employers report concerns about the abilities of people with disabilities, while concurrently reporting that disabilities don't factor into the hiring and advancement decisions, which kind of contradict each other because nobody wants to say that they're not adhering to the law, but at the same time, it is a concern. From a reasonable accommodation standpoint, willingness to provide accommodations has been influenced by previous experience with disabilities. The more experience an employer has had working with disabled employees, the more willing they are to make accommodations. Knowledge about the ADA. Knowledge of the ADA doesn't translate into changing attitudes about hiring people with disabilities, and they weren't able to see any real correlation between the employer size and the knowledge in regards to the American with Disabilities Act. Employer concerns. There are concerns about decisions to hire and or provide accommodations in relation to anticipated disruptions to the workplace culture. Employers are concerned about disability and or people with disabilities in relation to the perceived costs of job restructuring and modification, accommodations, and workers' compensation claims. Employers are concerned about hiring people with disabilities due to the fear of potential litigation and the perceived cost of litigation. Even though we've made great strides in removing some of the discrimination, you can still see, based on some of the employer concerns, we still have a long way to go. Here I've outlined a couple of relevant cases in regards to discrimination. And in this particular instance, where the EEOC versus Connections CSP, according to the EEOC suit, Connections unlawfully enforced a fixed leave policy that did not provide reasonable accommodations for qualified individuals with disabilities, and it refused to provide leave beyond the 12 weeks allowed under the Family Medical Leave Act, and fired any of those employees when their leave expired. The EEOC also charged that Connections denied other forms of reasonable accommodations that would have allowed qualified individuals with disabilities to remain employed, such as reassignment to vacant positions. Instead, the EEOC said Connections also placed those employees on FMLA leave and terminated them as well when their leave expired. Another example is the suit of the EEOC versus Stanley Black& and Decker. According to the suit, an inside sales representative who started working at Stanley Black& and Decker's Townsend facility in March 2016 told her supervisor she had been treated for cancer and would have follow-up doctor appointments throughout the year. In October, when she needed further testing that included a biopsy, the employee spoke to the human resources about her options, and human resource representative told the inside sales representative that there were no available options since she had not been employed long enough to be eligible for medical leave under FMLA. The EEOC charged that Stanley Black& and Decker filed the sales representative for poor attendance in December, even though she had met all of her employment obligations, and that her absences were related to her prior cancer treatments. And so the company did not follow its progressive disciplinary policy and fired the sales representative instead of giving her final written warning as was set forth in the attendance policy. And this was based on the employee alleging that this violated the American Disabilities Act. So that's kind of a summary of where I have gotten so far on my research and exploration of the American Disabilities Act. I appreciate your time, and if you have any questions, I look forward to hearing from you. Thank you.